of the Ethics and Practice Standards Committee here at the East African Law Society. And we are all elated to have her moderate this very topical discussion on this very important submatter that is on ethical leadership, law firm management, shaping the future of legal practice in East Africa. So without further ado, allow me to hand it over to our esteemed chairman to take it on from here. And I hope we all enjoy this session. Thank you.
Thank you very much, Gabriel. Good afternoon. Honorable Aisha Sindani, our very able panelists that we have with us here today. We have Dr. Kathy Mputhia, we have Mr. Joel Basoga, and we have Mr. Isaac Bizu Muremi. To the Vice Chairperson of the members of the Ethics and Practice Standards Committee, and to the honorable members of ELS, I do give you a very warm welcome to this afternoon to our very, very first session. Before I hand over to our panelists, I think it would be of good measure for me to actually give you a slight background in terms of the committee. So basically, the Ethics and Practice Standards Committee was established in March 2025. Yes, that's just a few months ago, and it was done so under the leadership of our current president, Mr. Ramadan Abubakar. It is an inaugural body committed to basically upholding the integrity of the legal profession amidst rapid socioeconomic changes in East Africa. As a bedrock of justice, trust, and societal order, the profession faces pressure from commercial demands, from technological disruptions, and public scrutiny, making ethical conduct critical. The committee includes representatives from the Law Society of Kenya, from the Uganda Law Society, from the Tanganyika Law Society, Rwanda Bar Association, Burundi Bar Association, Ethiopia Federal Advocates Association, and Zanzibar Law Society. It is enriched by ethics scholars and disciplinary specialists. Our key roles and responsibilities in this committee is developing ethical tools, monitoring trends, fostering networks, promoting reforms, knowledge dissemination, and reviewing standards. With that in mind, and with the theme that we have for today's webinar, which is Ethical Leadership in Law Firm Management, Shaping the Future of Legal Practice in East Africa, I'm very, very pleased to introduce to you to our panel for today. We have three panelists that will be taking us through the theme for today's webinar. We also have a keynote speaker who is Honorable Justice Aisha Ali Sinda. I will give you a brief bio for all our panelists and our keynote speaker. Honorable Aisha Ali Sinda is a judge at the High Court of Tanzania. She was appointed as a judge by the President of the United Republic of Tanzania on 3rd September 2023. She obtained her law degree from the University of Dar es Salaam in Tanzania in 2007. She also obtained a postgraduate certificate in economic law and competition from the European Institution of Foreign Studies, Turin, Italy in 2007. Judge Sinda further obtained her LLM in international trade and investment law in Africa from the University of Pretoria, South Africa in 2009. She engaged in private law practice soon after admission as an advocate of the High Court of Tanzania in 2011 and the High Court of Zanzibar in 2020. Prior to her appointment, she was a senior lawyer at Bowmans, Tanzania. Judge Sinda is the former vice president of the Tanganyika Law Society and served in its various councils and committees from 2013 to 2023. That's 10 years. She served as a board member of the Tanzanian Women Lawyers Association from 2022 to 2024. She has also served as a board member of the Council for Legal Education from 2015 to 2013 at the Law School of Tanzania and the Law School of University of Dar es Salaam from 2021 to 2023. And with this experience, it has allowed her to observe and to take stock of the Tanzanian legal education situation. Judge Sinda has been selected for the 2025 Judicial Fellowship Program at the Presidential Precinct in the USA. She was also named by Courtroom Mail 100 Women as one of the Africa's influential women in the legal profession in 2022 and 2024. Jacinda is zealous about community work, particularly legal education and training to lawyers, paralegals, and the community. She has established extensively in the field of commercial and corporate law in Tanzania. She is keen on she is keen on advancing opportunities for women in law in Tanzania. She's also devoted to advancing the rule of law and promoting the effective delivery of justice in Tanzania. Honorable members, I do assure you, I have not done justice to Honorable Justice Aisha's bio. I have shortened it for the reasons that we do have time constraints for today's webinar. Our panelists for today, we will start off with Dr. Kathy Mputhia. Dr. Kathy is a Kenyan advocate of 20 years specializing in emerging laws, data privacy, intellectual property rights, corporate governance, commercial law, and technology law. She's the managing partner at C. Mputhia Advocates, a Nairobi-based law firm. As a versatile advocate with a wide skill set, she has been involved in many consultancies ranging from corporate governance, where she has specialized in family business governance, and in emerging laws. She has been involved in several data privacy consultancies, where she has assisted her clients in conducting data audits, data assessments, data impact assessments, data certifications, and policy and data training. She has been involved in policy and legislation drafting, where she has drafted the copyright regulations and collective management organization regulations for the Kingdom of Eswatini. She has also led a regional consultancy with the EAC region on harmonization of intellectual property laws in the member states of the EAC region. Most recently, Dr. Kathy has led her team to secure a landmark victory in the world's first technovasion case, where she represented a technovator in a software dispute with his employer. The case was ruled in favor of the technovator both at arbitration and appeal level, and shed light on intellectual property valuation, formation of innovation policies, and rights of technovators to be remunerated. She's an accomplished author who has written the book Corporate Governance Handbook for Non-Lawyers and has columned with the Business Daily for the past 17 years. Our next panelist will be Mr. Joel Basoga. Mr. Joel is the head of the Technology, Media, and Telecommunications practice at HNG Advocates. He is a member of the International Bar Association Task Force on Artificial Intelligence. And for the past decade, Joel's practice and teachings have focused on data privacy, competition, antitrust law, corporate advisory, and several aspects of technology, law, and risk. Mr. Basoga is a graduate of the University of Oxford. He holds a Master's of Law, LLM, in Technology Law, specializing in data privacy and competition antitrust law as a Fulbright Scholar. Mr. Joel has advised and represented several multinational and technology companies on data privacy compliance. For the last 7 years, Mr. Joel's practice has focused on data privacy, competition antitrust law, and corporate advisory and litigation services. He is known for his deep knowledge and versatility across a broad range of data privacy, banking, and technology matters. He is a member of the ICT cluster of the Uganda Law Society and the East Africa Law Society. Mr. Joel is a dynamic lawyer with global perspective, having trained across 3 jurisdictions, that is, in the United States, the United Kingdom, and in Uganda. He has served as a lecturer of private and public law subjects at the university. He's a recipient of numerous academic awards and has presented papers at leading conferences in Oxford, London, and Washington, D.C., including the Privacy Scholars Conference held in the United States. Our next panelist will be Mr. Isaac Bisumuremi. Mr. Isaac is the founder and managing partner at Lex Chambers, a corporate and transaction law firm in Kigali, Rwanda. He has been in practice for the last 16 years in the areas of corporate law, commercial transaction, commercial arbitration, employment law, and corporate rescue. Mr. Isaac holds an LLM in international trade and commercial law from the University of Essex, England, MA in human rights law from the University of London, a postgraduate certificate in international business law from the University of Cumbria, England, and an LLB from the University of Rwanda. He's an arbitrator and a member of the London Institute of Chartered Arbitrators, a member of the African Association of Arbitrators. He's a licensed insolvency practitioner in Rwanda, a former member of the American Bankruptcy Institute. He's a member of INSOL International London and an INSOL International Local Partner. Mr. Isaac is currently the chairperson of the Insolvency Committee at the East Africa Law Society. With that, pardon me, that was a mouthful and very impressive bio. I do take this opportunity to welcome our keynote speaker for today, Honorable Justice Sinda. The floor is yours, and thank you very much.
Tanya. Thank you, Natasha, for the introduction. And good afternoon, distinguished participants. Greetings from Morogoro in Tanzania. It is such an honor to deliver the keynote address on this important webinar on ethical leadership in law firm management, shaping the future of legal practice in East Africa. Evolves, the need for ethical leadership in law firm management has never been more urgent. And today I will share strategies to help law firm navigate the complexities of managing conflicts, confidentiality, ethical dilemmas, and professional conduct in the digital age and a rapidly changing legal landscape. I think most of you may agree with me that in most countries within our region, law schools do not train lawyers to manage law firms, practice groups, or legal departments. Therefore, for lawyers who are trying to look at everything from an analytical point of view with the objective of developing an intellectually defensible solution to every issue, management of a law firm might appear to require experiences in finance, strategic planning, and technological issues. Additionally, while some larger global firms operate within the region and they have staff and formal procedures in place to implement and manage ethical dilemmas, such as client conflicts of interest, confidentiality, and professional conduct, we still do have a lot of solo and small practices which may not be able to do so. It is therefore important that we look at these issues, and I applaud the East African Law Society for doing so, and I will address the issues as follows. To start with, conflicts of interest are among the most challenging ethical issues law firms face today, and they can arise from representing competing clients, personal relationship, or even inadvertent disclosure. And in order to address this, law firm needs to establish robust conflict check system to identify potential conflicts at the outset of client engagement. Also, they need to develop clear policies to ensure all staff understand the firm's conflict management policies and procedures, and to foster open communication to encourage lawyers to disclose potential conflicts early to prevent ethical breaches. And secondly, in managing and upholding confidentiality in the digital age, I think law firms need to adopt secure technology as lawyers increasingly embrace digital drafting and the use of AI tools such as ChatGPT, Gemini, and Google Cloud, just to mention a few. And this can be achieved by utilizing paid subscription AI tools. As you know, with the increased use of AI, lawyers can easily put clients' information on AI tool and it remains there. And somebody else can easily access that information when searching for any other information. And law firm can also use encrypted communication tools, secure cloud storage, and robust cybersecurity protocols to secure client data. It's also important for law firms to ensure that clients first agree to the use of AI in their relevant matter or cases. And law firms should establish confidentiality and digital policies on the use of technology, including guidelines for remote work and data sharing. We have discussed conflicts of interest and client confidentiality as some of the ethical breaches faced by lawyers, but there is also dishonesty, misrepresentation, and a lack of professional competence. And ethical breaches by lawyers can damage a firm reputation and erode the client trusts and other stakeholders. With the increased use of AI tools by lawyers, I'd like to share some examples of lack of professional competence that courts have come across recently and how courts have dealt with it. In Tanzania, the judiciary has been integrating technology, e-filing, virtual court sessions, digitizing court records, and incorporating AI into the transcription and translation system. However, a serious issue is quietly surfacing on fake or non-existent legal citation, which may result in ethical breaches. In the case of Pham versus Zam, Primal Court Matrimonial Appeal number 212 of 2025, High Court of Tanzania at Mbeya, which is available on Tanzili. The counsels for the respondents referred to 6 non-existent cases, which did not support their propositions and were generated by ChatGPT. This case was decided in July this year, and the judge held that Lawyers have a duty to the court, clients, and to the administration of justice to faithfully represent the law to the court, not to fabricate case precedents, and not to miscite cases for proposition that they do not support, and the duty to use technology, conduct legal research, and prepare court documents competently. She further held that in case a lawyer presents fake authority, the court may impose different sanctions, including imposition of cost order, striking out a case, referral to a regulatory body, initiation of contempt proceedings, or criminal charge. Similarly, in May this year, Kenyan Supreme Court Judge Isaac Lenaola warned against AI use after lawyers submitted fake citation. Similarly, in South Africa, courts have also faced several episodes of fabricated citations, and in July this year, a junior advocate was referred to the Legal Practice Council. Also in July, in Zimbabwe, a senior counsel had to write a letter to the registrar to apologize to the alleged ships before whom his matter was placed for adjudication because he cited 12 defective and non-existent cases which were generated by ChatGPT. So I've given examples of recently ethical challenges that courts are facing because of the technological advancement. So what needs to be done to prevent these ethical breaches by lawyers? And we have seen that both junior and senior lawyers are captured in this. And for senior lawyers, it's simply because they did not supervise junior lawyers who did the research and prepared the submissions. In my opinion, I think law firms need to develop comprehensive code of ethics that aligns with international standards that govern lawyers' ethics. Firm leaders must model ethical behavior and hold everyone accountable to the same standards. And lastly, establish confidential reporting mechanism for ethical concerns, ensuring that whistleblowers are protected. In conclusion, as legal practitioners, we are entrusted with the responsibility to uphold justice, fairness, and integrity. By proactively managing conflicts, safeguarding confidentiality, and fostering a culture of ethical conduct. In such a way, we can strengthen the trust placed in our profession and ensure its sustainability. I urge you all to commit to leading by example. We should embrace innovation and technology responsibly and prioritize ethical principles in all aspects of the legal practice. Together, we can shape a future where East African law firms are not only successful, but also respected for their unwavering commitment to integrity. I think I should end there. I thank you all for listening, and I look forward to engaging with you all during the webinar. Back to you, Natasha.
Thank you very much, Honorable Justice Aisha Sinda, for that insightful keynote speech. On my part, I'm sure I can carry home with me three things. One, that we must lead by example. Two, that you have reminded us to embrace technology responsibly. And three, that in law firms, we can be successful, but also respected at the same time. Thank you very much, Honorable Justice Aisha. We do appreciate your presence here today and your keynote speech. Our next speaker is going to be Dr. Kathy Mputhia. She has a wealth of knowledge to share with us as well, and I shall allow her to take over the floor. Thank you, Dr. Kathy.
Okay, I hope you can hear me. Thank you to our esteemed panelists and Honorable Justice and all the attendees. I'm glad to be here today, and I'll be speaking, just building up on the theme of the webinar today. I'll be tackling three subtopics. And first, I want to talk about understanding principles of ethical leadership and its impact on firm culture. So when we talk about principles of ethical leadership, I think these are really what I can say, a bit of common sense when we talk about ethics. However, I used a resource that is from Harvard University, and they narrowed it down to six major principles that as leaders in our law firms and even as associates and all those who are working in the legal profession. So I narrowed it down to six, and like I said, they are common knowledge, but so we have the first one, which is obviously a culture of respect. Cannot talk about ethics and not have respect as one of the principles. We also have the principle of accountability, the principle of service, principle of honesty, principle of justice, and principle of community. And just breaking it down quickly, when it comes to shaping culture in a law firm using ethical leadership, when we start with respect, having a culture of respect in a law firm definitely shapes a culture in terms of motivating employees, getting commitment from the team, and even boosting performance. So respect traditionally is looked at based on the employee to, respect the leadership. However, respect is a two-way, and if I dare say three-way process, because there's a respect between employee to the leader, but there's also the respect of employer to the staff member, and there's a respect between peers. So all these need to be upheld in the workplace setting. And when we talk about accountability as a leader in a law firm, it's not very easy to be accountable to your team, but it is a principle of ethical leadership. And this is, I think, an intrinsic thing that a leader should have in terms of being ready to be vulnerable, admitting where a mistake has been made, and avoiding the blame game, blaming others. And when you set up teams in the workplace, these are very good forums in which accountability, in which a leader can also be accountable to the staff. When we talk about service, service leadership or servant leadership is really the type of leader that transforms their businesses, transforms organizations. And when a leader prioritizes service or servant leadership, it has an impact on staff welfare, it has an impact on even the clients. So as leaders in our law firms, we could prioritize customer service, prioritize staff welfare, and also community welfare. When we're talking about honesty, I think Honorable Justice has really gone in depth in that. And having that culture also builds trust with your staff and your clients. And when we are talking about justice, we are talking about fairness in decision making, fairness in how we treat each other. But let me talk about how these principles shape firm culture. And when there is ethics in a law firm, it benefits, first of all, the employees. There's a lot of motivation, performance is good, and there's also increased commitment and engagement to the firm as a business. Now, there's this new category of staff called the Gen Z, and research has shown that for the Gen Z, they had rather work in a business that aligns to their own values. They're very value-oriented generation, and they also want to make an impact. They want to feel that they're making an impact wherever they are. So for this type of category of generations, and of course others, having ethics motivates in terms of value alignment and impact. Of course, ethical leadership has an impact on the client. It has an impact in terms of you build trust for your law firm, you build trust for your brand, and therefore there's a high brand reputation. And this brand can, when you have a reputation of being ethical, as the good book says, that a good name is better than silver and gold. So a good reputation and a reputation of ethics is one that can draw clients. It's one that attracts clients. It even attracts investors in some cases. So one last thing in terms of shaping culture, having a culture where there's ethics, where there's respect, there's trust, there's honesty, you manage to build a culture where there's a speak-up culture, where employees are free to give their views, they are free to give their opinions, and that is very good for the firm because it ties down to innovation, where when people are able to speak up and give ideas and share what is on their mind, then it boosts innovation and teamwork. So maybe the second thing I was asked to look at is how can a leader lead by example while balancing client service, profitability, and integrity. So to lead by example means that as a leader, you practice what you preach. You are ethical. It's not just a standard you put for others, but you're constantly and consistently practicing what you're preaching as an ethical standard. Now, how does integrity, what's a correlation between integrity and client service? So for me personally, I feel that when a law firm has ethics and integrity as a core value, then this actually attracts the right clientele. For some clients, values, integrity and ethics is a very important thing, especially in today's market where we've seen those cases where clients have been, messed up by lawyers and so on. So trust is a very important thing for some clients. They want to feel that they can trust you. They want to feel that you're honest with them. And therefore, when you have ethics and integrity and you're intentional about it, then you're able to draw in clients and you're able to serve your clients better in terms of client delivery. And the reality or the truth of the matter is there are those clients who want the lawyer to take shortcuts. I don't know about you, but for me, I've maybe been approached by one or two, and they say, we have this money here. Can you facilitate this transaction? But when you meet that kind of a case, it's good to stand your ground. And it is better to let go. It's better to say no and to keep your respect, to keep your reputation. Because there's no brief that is worth your own reputation, because your reputation is something that is intrinsic. It is something that is your personal worth. So we need to be very bold in taking a stand and saying that these are our values and we cannot compromise them. And some of the practical ways to do it is in the customer care policy or the client service policy or whatever you may have as a firm, is to embed your values and to embed your principles in these policies. And from the word go, a client knows that if I'm engaging with this law firm, these are their values, these are their principles. Also having a no bribing policy and in our HR policies that bind all staff members, all our stakeholders are bound to these policies. And therefore, using these policies as a tool, we'll be able to communicate your values and your stand very clearly. So in terms of my the last thing I was tackling was how do you develop mentorship and training programs to instill ethics in the firm? So it is one thing to be the ethical leader. It is another to build a culture. But it's also important to raise people who are also like you and who will also emulate the same values you have. So I feel like it begins at recruitment. When you're recruiting candidates, it's good to look for candidates with whom you share the same values. And there are many ways of testing that. There are many ways of testing the integrity or ethical levels of the candidate you recruit, so that you make sure that you're aligned with your candidates. Then it is important to have a policy. All these policies that touch on ethics. Honorable Justice has talked about conflict of interest policy, AI policies, even data protection policies, customer care policies, all these policies that touch on integrity and ethics. It's good to have them, but it's also important to consistently train your staff on these policies. And in those policies, giving actual case examples and giving leadership and guidance on how your staff are expected to handle certain situations that come up. Sometimes it's good to get external coaching on ethics and integrity. There are those coaches. There's a school I've seen that coaches organizations on ethics, on integrity, so that you can have a holistic approach to it. It's also important to consider if, as a firm, you can join some of these institutes which uphold ethics and integrity. And finally, in the HR policy and employment contract, you can actually be very firm about issues of ethics and integrity, such that it becomes a terminable offense if a staff member breaches or engages in unethical conducts and practices. So those are that's my short view on ethics and integrity and how leaders can drive this in the law firms. Thank you, and back to you, our moderator.
Thank you very much, Dr. Kathy. I know you had a wealth of knowledge to share with us, and I believe that a few takeaways that we can have from your presentation was that we should always have a culture of respect, and that's definitely two ways. There should be accountability of the leaders in the firm. We should have service or servant-based leadership. We definitely have to lead by example. Our leadership has to be intentional, and that basically the reputation that we have is intrinsic and it's our personal worth. So with that, Dr. Kathy, please allow me to ask all our colleagues who are present, if you have any questions, kindly feel free to drop them in the chat. That way, once we're done with all the panelists and speakers, then we can come back to you for the question answer session where we can actually have a discussion based on the speakers' information. Next, we'll be having Mr. Joel Basoga. I had already given you our introduction, his bio on the stage. So Mr. Joel, you can take it away. Thank you very much.
All right. Thank you very much. Natasha, I hope you can hear me and that my slides can be seen.
Yes, we can hear you and your slides are visible.
Okay, so I was asked to speak briefly for between 10 to 15 minutes about how do we shape the future of legal practice, especially with innovation and ethics. And I think that that just basically entails understanding the role that technology can play in practice, because most of the innovation that we have, some of it can focus on client experience, but most of it is around technology that enhances delivery of service to clients. So my presentation will speak a little bit about the prompts on integrating technology into practice, what are some of the ethical considerations, and also promoting diversity and inclusion, and then a few key takeaways. I would really take this presentation as really just a food for thought. I think it builds onto the discussion of the Honorable Justice and the doctor who has just discussed some of the key ethical issues. But really, the big picture is, in East Africa, there's been a growing number of lawyers, but still, there's still a huge demand in terms of the lawyer-client ratio. There are still fewer lawyers compared to the potential clients. And digital transformation, which is a wave that is part of the fourth industrial revolution, has affected the world in different ways, and so has it for the law society, both across the regions. So digital transformation is here with us. The practice of law has changed. I remember about a month ago, we were attending a digital transformation festival organized by the Uganda Law Society. And we had a partner for one of the oldest law firms in Uganda who shared his experience of how the law has changed or how law practice has changed. They used to write physical letters, then they adopted a telex machine, then they used to use a fax, then they were part of the revolution of the emails. When emails came, they were the first law firm in Uganda to use emails. Because of that, they were then able to get a lot of business just by being accessible and adaptable. So we see that even from that illustration from one of the old law firms in Uganda, we see that digital transformation has come, but also there's still a need for the traditional strength of an excellent lawyer, being trustworthy, inclusive, and also having the core values of the legal profession. I think as we think about technology, we have to know fundamentally what the duty of a lawyer is. And the lawyer's duties are best understood through a trinity: the duty to the court, the duty to the client, and the duty to the public. Lawyers obviously have an obligation to uphold the rule of law and justice, but they do have specific obligations to the client and the court. But of specific importance to this discussion is the duty of confidentiality, which I think is important, especially as we engage with technology, the duty of decorum, which applies mostly to court, but also the duty to exercise professional responsibility. And the Honorable Justice mentioned earlier and gave a detailed expose on how the negligent use of technology can lead to a breach of one's duty of competent representation. But there's also a duty to act diligently and a duty to disclose conflicts of interests. Now, these are some of the fundamental core duties of a lawyer, and we'll come back to them, especially when we see the ethical considerations of AI. But really, there's this quote which the American Bar Association has published, which reads, we suggest that lawyers have a moral responsibility for what they know and for what they do. Their responsibility is complicated by the responsibility also a moral responsibility that lawyers have to clients. But lawyers should not hide from the complications of a moral life. Behind the illusion that the adversary system will yield a just result, the issue is not whether moral soundness in life is easy, it is whether lawyers are disabled from pursuing moral soundness. Certainly, determining directions indicated by justice and mercy may be difficult. Really, the court is a food for thought. Lawyers have a moral responsibility to their clients, that's in line with the duties discussed on the previous slide. But in terms of technology, we have different opportunities. The artificial intelligence has been incorporated already. It's not new now. There's electronic filing, there are virtual hearings. So we have certainly technology has been incorporated even in the justice sectors, in terms of court appearances, arbitrations. And there, if we had more time, I could have gone in detail in how technology is changing arbitration and the legal system. But since this is an association of legal professionals, some of the key things are, for instance, practice management systems. Most law firms now have a practice management system where they manage their client portfolio, where they track the progress of the billing, the work of the associates and the partners, and so a lot of law firms, even the law firms that I'm affiliated to, provide this service. So, and these come through different, in Uganda, the smart case is quite popular and novel, but also AI has been incorporated through internal models. And also we know people have designed AI models that help lawyers in doing research, applications like Jibodocs, Harvey, and then different organizations have come up with internal models of AI that they train on the basis of the work that the firm has done to be able to generate some precedent documents. But also we've seen filing systems, and also we have a number of lawyers. Actually, most lawyers, there's a survey that was undertaken. Most lawyers actually use open source large language models to undertake work. And this is one of the points that the Honorable Justice mentioned. We see a lot of lawyers post information in open models like ChatGPT, Gemini, and they use those facilities to advise their clients. Now, there's certain challenges with that, and perhaps we're going to get into that. So some of the ethical concerns as we deal with technological tools are data privacy concerns, obviously. Remember, one of the core things that enables a lawyer to perform their function is the duty of confidentiality. This duty is so important that it is a guarantee that allows a client to confide into a lawyer or their lawyer, and it is highly protected. When we use these digitized systems, these systems might be open to data security incidents. Some of them, especially if you're sharing data on open language models, you're not sure where that data is going and if it can be retrieved by the owner of the platform. And that's why there's been an argument that if you're using AI models, design internal ones, although obviously there are limitations to that in terms of the actual cost for setting up AI models and the data centers that they have to run. So some of the ethical concerns under threat are obviously the duty of confidentiality. If these systems are accessed, information that ordinarily lawyers 30 years ago would store and lock away in a safe can be accessed publicly, which can hinder a client's prospects of success. There's also algorithmic bias in AI tools, and I think that has been mentioned in the several use cases of AI in Africa, in Europe, and in the Americas. We've seen that there's bias. AI relies on the data on which it is trained, and because of that, there's bias in terms of it could be on gender, race, but also it could be on other social demographics like financial standing, but also even the location, the place that people stay. And the Honorable Justice spoke about hallucinations. Some of these AI tools can create information that does not exist, and that has been false citations. And when you cite a case that doesn't exist, that goes to the heartbeat of professional competence, which is one of the values that we spoke about. But also there are concerns about data breaches. If you're doing a technology case management system, if your system is hacked, your information is out there. If there is, an online virtual court system that is using open source cabling and it's supposed to be a confidential hearing, what if on the back end that hearing is accessed and then the information from that hearing is used by others? So that data breach is a really a critical issue, but I also think that competence in using new systems is important, because while you have tools like AI, case management systems, you have to build the capacity of the team. Most people do not know how to use these AI models or these case management systems, and therefore that if you don't train them well, then they could leak information that should not be there. And this all relates to the duty to perform competently. Now, obviously, there are a number of things. Data protection laws are critical when you think about technology. And in Uganda, and I know that all the other countries in the East African community do have data protection laws. But in Uganda, we have questions of consent. Before you run sensitive data into a system, you must get consent. This consent is required, except under a few circumstances. But also, if you're going to use a machine to make an automated decision, there's a requirement that you must notify the relevant person. And we don't have so many laws on this area, but the EU AI Act does provide some form of comparison. But another key point I was asked to speak about as we think about innovation is the role of promoting diversity and inclusion. And diversity, obviously, and inclusion has come under debate over the last couple of 2 years since the change of power in one of the major countries in the Americas. And perhaps there's a contentious discussion on whether DEI should be inclusive in the progressive development of corporations. And we've seen international law firms, due to strong affiliations to America, suspend their DEI programs or create new names for these programs. But I still think that diversity and inclusion could carry significance. There's need for equal and gender representation. Diverse teams are much more inclusive, and clients can trust teams that are inclusive, because that speaks towards the values of the organization. But I think mentorship can also be a critical tool for inclusion. And that ties into sustainable growth, where there is a clear on-cut communication, where you think about sustainability. How is the work of your business? How much paper do you use? Are you training the future generation? Are you thinking about sustainability? There's a challenge with law firms, in certain parts of the world, especially in the global south, that do not think about succession plans. And they're mostly built to serve the founding partners of the organizations. I think sustainable growth does include thinking about succession, but also considering the sustainability of the practice of law. But what does the future like as we think about innovation and legal ethics? I think there's going to be more integration of technology in legal practice. AI is going to play a central role. I see that right now we're being consulted on helping the International Bar Association on coming up with guidelines for the use of AI in arbitration. I think there's going to be a lot of work on AI policy and laws that's going to continue over the next 15 years. Like I said, we only have the laws that exist on AI are quite minimal globally, and the most laws that people know about is the European Union AI Act. But also the obligation to respect privacy rights is going to become important as we incorporate such things. So innovation must work hand in hand with ethics, inclusion, strength, trust, and leadership, and governance is the foundation for good governance. I just have a few last words. Always ask yourself, as you use these technologies as a lawyer, are you using personal data? Do you have consent to run that data through that system? Do you have consent to run personal data or clients' information through these open source AI models? It's a different debate if it's an internal AI model, but also I just think that the regulation of tech is fast changing. And as the legal profession, as the East African Law Society, Uganda Law Society, Kenya Law Society, Rwanda Law Society, we have to think about most of these things. We need to think about things like data protection policies, AI policies, because these are going to guide the internal approach of the risks that technology presents. Otherwise, it's been such a great honor. I tried to cram up my presentation within 13 minutes, and I'd like to hand back to Natasha. Thank you very much for this opportunity.
Thank you very much, Mr. Basoga. Thoroughly enjoyed your slides. I do feel like you've left us with a lot to think about and a bit of concern, especially in terms of the data breaches vis-a-vis our duty of confidentiality. We may be hounding you after this presentation to find out how is it that we can actually protect our firms and our clients from that. Thank you very much, Mr. Basoga. We now have our final speaker, who is Mr. Isaac. I believe he's already logged in. Mr. Isaac, we look forward to hearing from you. Thank you.
Yeah, thank you. Thank you, Natasha. Thank you, Joel. Thank you, Honorable Justice Aisha. Thank you, Dr. Kathy, for all your previous presentations. And I don't think that my presentation or my intervention on this subject will be substantially different from what others, particularly the Honorable Justice and Dr. Kathy said. Joel was much more on digital and technological tools. And yeah, so all these are very much relevant today in law firm management. So my task was to talk about governance risk and governance risk and governance risk and compliance in law firm management. I will start with this picture here that let the law firm managing partners, and I know this now concerns the senior partners, not the associates, not the interns, not to. So just assume that your firm is your first residential property you have put up, and you have a family of 6. With that assumption, think of the protections. First of all, the value attached to that dwelling. Second, the protections you would put in place to ensure that that dwelling survives the external threats, night and day thieves. What would you do if you are asked that what measures can you put in place to ensure that your dwelling is safe? When you leave daytime to go to work and come back, and you go with a peaceful heart, believing that you come back and find everything safe. What would you do? So the lesser the value attached to that dwelling, the lesser the protections you will put. And the level of protections you will put to protect your dwelling will determine the amount of investment you're going to put in that. So legal business is not an ordinary business where you switch to products that are profitable at the time. For example, if in the morning beans on the market were high value, you cannot change from tomatoes and go to beans. In legal services, you don't do that. Legal services, whatever, you can switch to areas of practice, but they all fall under the legal practice. So using the metaphor I just mentioned about the dwelling, what would you do in such a situation to ensure that you put in place safeguards that will ensure that your business, your law firm business, will continue at all costs of the pillars that Honorable Justice Aisha stated and what Dr. Catherine mentioned. So they mentioned about integrity, they mentioned about confidentiality, they mentioned about a number of issues. Those are major pillars of a law firm, corporate governance. So the law firm, the fact that it's called the law firm, it's not different in terms of governance. It is not different from other, its governance is no different from other good business structures. And so governance in this, it must be there. That's why some people carry titles managing partners. You manage what? And by the way, even if you are sole partner, you can still be a manager of yourself. You must put all other safeguards, procedures in place because of the stakeholders involved in your practice. Without clients, you cannot be there. You will not be having what you call a law firm. So your presence on the legal market already opens a window of risk to the stakeholders who are your clients. And now, how do you ensure whether you are a sole practitioner, whether you are a partnership, how do you ensure that your clients, you manage your office in a way that your clients' interests are well protected, and not for only one case that you deal with a client, just believing that the modus operandi that you put in place is going to be the pillar of your sustainability for the next 100 years. You, as an individual, may not live for over 100 years, but we believe in the continuity of your business as a lawyer. Now, I want to come back to, I will not repeat what others mentioned, but as a matter of emphasizing my point, what others mentioned, I want to talk about the conflict of interest. Conflict of interest is very wide, but how does that become a part of governance structured in your law firm? So I will give living examples that are open to myself that I use mostly. For me, when any new entrant, when you come as an intern, you come as an associate, instead of thinking of a contract that that determines the terms of our relationship, I start with you signing the confidentiality agreement. And I tend to take time to explain to you what that means. At one time, I remember there was an intern that came, and I had made sure that this intern had signed the confidentiality agreement. And then, as this intern was trying to search for best opportunities, this intern used in the CV that he or she did. She used the word he or she. I'm not going to use the word. I will be using he or she so that I can probably confuse the identity. But he or she went and outlined all the work naming the clients, parties in their CV. And I came to find out this, and it was a very short time. It was just probably like 3 months after induction to these principles. So the good thing that I mean the mitigating factor there was that this application was being made to a farm that was friendly to me, and I had to inform the managing partner of this farm to say that, please, you received information that was privileged, not from me, but just because of lack of experience from our intern. But please don't use this. Keep that information confidential, and where necessary, please delete that. So this information here that regards now confidentiality, you can imagine how far this information will to go. I don't know where how many applications that this intern made, including probably private companies. I don't know. So that's a risk. So now the question is here now, as a managing partner, how do you manage the information of your clients? How do you, in governance, ensure that the information of your client is well protected, and it protects information, but also it protects their integrity. So if we don't have these safeguards, then we put at risk the data of our clients, and also in the end will affect our practice. And we may have to go back to Shamba. We may have to go back to the village and start digging when we lose the trust from our clients. So confidentiality, managing that. How do you manage that? Every farm will have different ways. I cannot say that there is one standalone governance rule that can suit every farm. But one of them that is very clear is this to be a gospel that is preached regularly to your members. First of all, it must appear in contracts. It must appear in the in-house policies. It must appear even in every communications. For example, that in the email, make sure that you put at the footer certain protections that for example, if this message is not intended to you, if you receive this message that was not intended to you, kindly delete this message immediately. Those are one of the things. But the point I wanted to make here internally is the farmer must always have a periodical calendar to review how this policy, how this risk has been breached, how it is protected, and you get feedback from the members in the farm. That's one point I would say. But then there is also now what Joel talked about about the technological tools. We are much encouraged to use IT, and yes, it's there for us. The innovators have invested a lot and seems to be working for us. By now, I think Joel will probably comment on this. I've come to be told that the more information you feed these AI tools, actually at certain time is associated with your identity or with your farm. To the extent that when you are searching, maybe if you feed the document without anonymizing the parties, though the identity of these parties will likely remain in will remain in the AI database that you are using. And so any other person can just find maybe an agreement, the agreement between your client and another party, just because the way you fed it. So we need also to have these tools that and information to ensure that we have the guidelines on what to feed the AI tools. We should always anonymize the parties and where applicable case numbers. For example, if you have to put a judgment in your that is not an open, and then it has, maybe if you want to appeal, maybe it's an arbitration award, and you want to appeal, and then you ask AI to do an analysis. Without anonymizing the parties, probably this is likely to affect the confidentiality principle that we have. The other point I would like to talk also with is how do we ensure that our new members that are coming in becomes compliant. We all know how we came into the business, into the field of law. We come with very green mind. We don't know left to right. We don't know what. And there you try to struggle. Joel said that they want to be, especially the junior, they want to be relevant. They want to do a lot using AI tools, and they want to be relevant to your firm. But before they engage into this, please try to see that at least you provide the minimum training if it is possible. But if training is not possible, by the principles at least you can provide. So that they should be knowing what is risky, what is not risky, what information is very sensitive to your clients, which information that can never be shared in any case, who to share everything. So these are matters that governance tools must have as at the starting point. So you don't just usher in a new entrance and then you think that they are going to bring all you presume that they know. At the end of the day, you, the managing partner, you bear the credit and the blame and the shame for what your associates do. The other point probably I want to mention here is I think they talked about the conflict of interest. This is very, very vital and very prevalent now. I don't know in your jurisdictions, but we have in Rwanda we've had the cases where lawyers have had to switch sides. So the lawyer starts with defending this client, and when the respondent finds that this lawyer is probably smart, and then approaches him or her to resign from the other case and switch to him. We had one case, there are not many. We had one case, and the bar took serious sanctions against this. So, but because when we join, we have disagreed, we are very poor. I'm talking here in Rwanda, I know in other jurisdictions they are not. But they are very, we want to have something quickly in a short time. And so we don't know that we have limitations, ethical limitations on the type of income we can earn and what we cannot earn. So our process, our business is governed by the processes, governed by ethics, is governed by integrity. Those are underlying pillars that should be the guiding principles when you are taking on the client, when you are choosing to take on a case, when you're doing what, it should be your day-to-day thought when you're practicing. So we just have to build integrity, professionalism, and of course skills as well. But these are just mere statements, but their meaning are very wide. When you say professionalism, you can write pages and pages on that. When you talk of ethics, you can write pages and pages on that. So we just integrity, professionalism, and ethics. They are all brothers and sisters, and you cannot have one and leave the other. So in governance, these must be much detailed. They must be repeated periodically, and there must be reviews on how the firm is complying, and where there are receipts, we establish the mitigating ways and how to prove so that such breaches are not repeated. I want to stop here as of now, and maybe we'll come back later in the Q&A session. Thank you.
Thank you very much, Mr. Isaac. I think it's safe to say that whatever one country faces in East Africa in terms of issues in practice, then the other countries do face the same, if not similar. And I'm referring to your issue of ethical limitations and the conflict of interest, where you switch from representing one client in the matter than representing the other in the same matter. I do take away from your presentation and what you spoke about is basically that we are responsible for what our associates and our employees do, and that we always have to remember that there's issues of integrity, professionalism, and ethics in everything that we do. Thank you very much, Mr. Isaac. And with that, dear members, we have finalized with all our speakers and the keynote speech. I had asked that if anyone had any questions, comments, concerns, they could have dropped them in the chat. I do see that we have a question from Faith. Please, if you have not put in your question, feel free to do so, or you can just maybe raise your hand and then we can move forward with that. Faith Mutuku had a question, and I believe that question is basically directed to Dr. Kathy. She's basically seeking clarification in terms of what HR policies should an organization or law firm have. Dr. Kathy, I believe that question is directed to you.
Okay, thank you. Thank you for that question. Yes, thank you for the question. And when we're talking about HR policy, of course, we understand that a law firm has different types of employees. It's not just the lawyers. We also have the non-lawyers, maybe the admin, IT, marketing, and all that. So the HR policy, if I've understood your question well, so you have talked of what are the different HR policies an organization or law firm can have. So like our previous speakers have talked about data protection policy, AI policy, customer service policy. But in my it can be, you can also put all these ethical issues into one policy, the HR policy, and you can have different chapters for different classes of employees. So for example, associates and advocates are bound by the Code of Conduct, by the Advocates Act. Then you have another set of employees, maybe the finance team, they're bound by the rules of their profession. So just to mention a few, data protection, AI, customer care, you can even have whistleblowing policies where staff members can report issues of unethical practices. You can go as far as having policies on environment, how to observe ethics in environmental practices. And I know this is very important for donors and partners, like maybe in the UK and so on. We dealt with one case where the partner insisted that we must have policies on human trafficking, policies on anti-slavery. And so what I want to say in closing is that policies that cover ethics are very wide. But to make it easy for staff to follow, you can also harmonize them into the HR policy. I hope I've answered the question. Faith, I hope I've answered. So back to you, moderator.
Thank you very much, Dr. Kathy. Looking through the rest of our chat, I can see that we have a message from Kisa Emmanuel from Uganda. His is not a question. It's basically just a comment, and it's directed to, I believe, Mr. Basoga. He said, thanks to the previous speaker, I have really benefited and learned a lot concerning ethical behaviors in the legal practice, inclusive of embracing the new technology. So, Mr. Basoga, that's an acknowledgement to you. We have a question from Amor, who's basically asking Mr. Isaac. His question is that you highlighted a very important point regarding feeding the AI platforms with clients' information. So his question is, how best can we make use of AI without endangering the privacy of our client, given the fact that AI tools make a lot of our work easy, especially in drafting of legal agreements? Maybe Mr. Isaac, you can take that one before I move on to the next question.
Yeah, thank you, moderator. Amol, I think your question is very pertinent, and so one of the tools that I mentioned is that when you are feeding the AI tool any information for searching, just anonymize. In other words, you can remove the names or replace the actual names with the different names that do not that are not real. And then if this has to be stored, then the information on the parties or party of your client will not be stored in the AI tools. That's one. Secondly, try to see that before you feed it, you can do some paraphrases. You can remove some phrases, basically to ensure that the information you feed there is not actually the same as it is in its original. And I think that one will in one or the other protect the identity of your client. For example, if you represented a client, your client is called maybe Bank of Uganda, then you have to say, Bank of, just think of a country name that does not exist. For example, we normally see these cases when we are in trainings where the trainers bring just unreal names of jurisdictions that you can never find. So in the same way, you can do that. I think that's what I can say at the moment, because when you change the name, the real names, the AI tool will still give you the same answer, and it will store unreal different identities of your clients. I think Amor, that's what I can say on this question. Natasha, maybe I can go to the next question by Robert.
Sorry, Mr. Isaac. So I'm seeing that Mr. Basoga wants to chip in as well, in terms of Amor's question. So maybe we can allow him that opportunity, please. Then we can jump on to the next question. Thank you.
Yeah. Okay, all right. Thank you very much. I just wanted to add, I think Isaac is spot on. I think anonymizing the information is a good thing. But also, if your organization has resources, or there's some organizations that are part of global networks, they have come up with internal models that are closed large language models that they are not open sourced in the way that once you feed in information, it's going to go to the back end of a private company that you could design an internal model that is closed. When you design an internal AI model, it is owned by the partnership. It is not breaching confidentiality requirements because it is within the institution. So I just felt that's something sort of like add-on. But if you are using open language models, I think that you can also set the preferences depending on the model that you're using. Sometimes you can select that if I input this information, it will be deleted after 30 days, and there is no historical information. But that's not usually the case because most of these open language models, they want to be able to learn from the information that you're feeding, so they'll not give you that much autonomy. If you need autonomy, there are a lot of AI innovation companies that have designed models that can be internally configured. Those will offer more security. They can even offer a layer of encryption in that when information is submitted therein, sorry, I think my network jumped. I don't know what the last thing you had.
That's okay, Mr. Basoga. I think you may have to go back a little bit just so that we can tie it together to what you were trying to tell us.
Okay, sorry about that, but I hope I can be heard. Now, I was just saying I agreed with Isaac's comments. I think that anonymization is the way to go. The other solution to that can be if the organization can partner with other institutions or affiliated law firms. We have seen that law firms have created internal AI models. Internal AI models can sometimes they are part of a closed network. So if they are owned by the institution that has designed or paid someone to design those models, you are less likely to be breaching any confidentiality obligations. But also internal models may allow you to encrypt the data that is fed into that AI model, such that even if there is a hacking or an incident, the data cannot be understood because it will be encrypted. I was also saying that if you're using an open language model, another solution could be, depending on the type of model, sometimes they can give you an option that once you have used the system, it will automatically reset and delete the information within 30 days or so. Sometimes tinkering with the settings of each language model could vary. But I think the safest thing to do if you are using AI models is to develop internal models or pay subscription licenses to models that guarantee encryption and that will be tailored to ensure that the data that is entered into it is not used or accessed illegally by third parties. Those are my comments. Thank you.
Thank you very much for that input. I think we're now safe to move on to the next question, which is directed to Mr. Isaac. The question is basically, about how can managing partners guide junior associates and perhaps trainees in approaching clients and courts in general when representing the firm? That's the first question. The second question is it advisable to let junior advocates or junior associates handle contracts negotiations on behalf of the firm?
Yeah, thank you, Natasha, and thank you, Isaac Karuben, for the questions. Two questions you have said. Let me begin with the second one. The second question says, how is it advisable to let the junior associates advocates handle contract negotiations on behalf of the firm? Yes, Ruben, first thing is that one of the ways of empowering a junior is to give this freedom with the prior guidance to meet, to handle and transact a certain work to completion. When I talk of this guidance, I mean liberty. It doesn't mean that you will not check. You as a managing partner or other partner, you retain the role of quality assurance, but before you let the junior or trainee approach the client on behalf of the firm, you must be sure that you have this associate has all it takes to undertake this assignment to the conclusion. Because you as a managing partner, you must have these skills to know which junior hacker is better in this, who is better in this and this, and then you have to assign the tasks according to your appreciation, that is based on the skills assessment of each junior. So it's very important that you delegate or you allow this associate to go and to ensure that you conduct this contract. But on my part, I tend to do this to clients whom, for example, we have a retainer, whom we have had a pre-existing relationship, so that if the associate has done some, there's some inconsistencies, then this client will probably come back to you and tell you that Isaac, would like you to handle this or to work with your associate because I think that's when the work can be completed well. But for the first time clients, if the associate goes, if the associate just deviates a bit, maybe on ethical grounds or whatever, or in skills, then this client might go once and for good. He never come back and may not know. And it is the first meeting, for example, in the first meeting with the first client, this is where you gain the point, your firm gain the points or lose them 100%. So when you send this junior, please, if you have a trust in this junior, but make sure that you repeat these things. Because this client may ask questions the junior, and the junior may give confidential information, thinking that he's actually doing good for the firm. For example, the client may ask, can you give examples of similar work you have done in this particular matter? And then you say, yes. Actually, last year and even right now, we are doing the work for so and so, and you mentioned the parties, you mentioned what, and then the client will say, oh, so even this is how my information will be disclosed to another client in the future or after this, and the client will have to go. So when you are training, you train how to anonymize or to have you tell the client how you are capable, how your firm is capable to do the work that the client has, but without disclosing details that pertain to the personal data of the existing or prior clients. That's what I can say. I repeat, empower to let the associate handle represent the firm with the client, negotiate contract or do any other work. It's very vital. It empowers it empowers the junior, and it is part of the learning because when this junior completes the work, that's you're already doing an assessment and to ensure that you also gain the confidence that next time this associate will handle the case. But the prior groundwork is your responsibility to ensure that this associate has understood the red lines that he cannot do. He cannot go beyond when talking to a client, all those things. Then the other question was how can managing partners guide the junior associates and past trainees in approaching clients and the courts in general? I think for the clients, my answers are not different from what I've already given. So you prepare, you train. When I talk of preparing, I'm talking training, empowering your associates with how to handle clients. What I do in our firm, what I do is that whenever I get an opportunity to have a first-time client, I make sure that I go with one associate so that we get information from day one together, and then we proceed so that this associate, if this associate is going to proceed to handle this, at least we have known or we have seen how I interact with the client, how we talk, such a thing. So it's always good to involve a junior lawyer at the very beginning. Personally, I have difficulties in transmitting the message. When I go alone and I meet the client, I do not relate very well to the associates, and sometimes I may miss out something. So I prefer to go with them at the beginning. Representing in courts, of course, if they have practicing certificates, they can represent the firm, and there's no question on that. You don't go. Actually, what happens in the court is just a defense, and it's just defense. And in this situation, you will have, before this junior associate goes to court, you will have already done the homework together. The associate can ask you if the judge asks me this, normally how do you respond? So normally that's how I do, but again, letting the juniors go to court, either you can go together so that they can gain experience with you, or you can do the groundwork at home with them, and then you can let them go and it also depends on it should be a case by case. Isaac Ruben, I don't know if I have endeavored to answer your question, but that's what I have to say on your question. Thank you very much for asking this question. Thank you. Back to you, Natasha.
Thank you very much for that. Should I say a question from Isaac and answered by Isaac, but we appreciate that. I'm not sure if we have any further questions because I don't see anything else that's been put in the chat. And there's no one here that has raised their hands to ask any further questions. I do believe it's safe to say that we can say we're coming to the end of our inaugural webinar. And with that, I would just like to say thank you. Thank you very much to our keynote speaker, Lady Justice Aisha Sinda, I'd like to say thank you to our panelists, Mr. Joel, Dr. Kathy, and Mr. Isaac, for their very impactful and informative session. We highly appreciate you taking the time to spend this afternoon sitting on our panel. In the same breath, I cannot close off without saying thank you to the Secretariat. We highly appreciate your dedication. And as we conclude, let us remember that ethical leadership is not an abstract principle, but a daily practice. The way we manage our firms, guide our teams, and serve our clients will shape the very future of law in East Africa. Leadership in our profession is not about position, but about influence, anchored in integrity, accountability, and service. So if we are to build a legal community worthy of the society's trust, we must then hold ourselves to the highest standards in every decision that we make. The future will not be shaped by chance, but by our deliberate choices, choices that must always reflect courage, professionalism, and ethical responsibility. Let us go forward committed to leading with integrity, managing with transparency, and practicing with purpose. Everything that we've heard today, let us implement it in our everyday life while managing our firms and while interacting with our clients and the society in general. That is the only way that we will safeguard the rule of law and secure the legacy of our profession. I do sincerely thank you for logging in and participating in today's webinar. Please do look out for other upcoming webinars from our Committee on Ethics and Practice Standards. As I mentioned, it is the recent addition to the list of committees in East Africa Law Society. You can call us the baby of the group, if you may. So we do hold our hands and as we navigate this course. I thank you very much, everyone. You do have a good afternoon.
Thank you, Natasha.